I had enough of Brawny. Wherever he go, it don't matter to me. I don't think he'll ever see another championship again. I could be wrong, but let's get to the feature premiere for tonight, which would be my guy Keefe D once again in court the other day, right? I want to show y'all something, right? But let me do my legal thing. Copyright disclaimer under Section 107 of the Copyright Act 1976. Allowance is made for fair use for the purpose, excuse me, I got the burps. For the purposes such as criticism, comment, news reporting, teaching, scholarship, and research. Fair usage is used permitted by the copyright statute that might otherwise be infringing nonprofit, educational, or personal use tips to balance in favor of fair use. And let's go to the courtroom in Keefe D's case, right? And remember, Keefe D went to court Monday, I believe it was, Tuesday, with motions to suppress the jury, to suppress the book, and also his 2008 statement to Greg Caden. Shout out to you know who. Going Greg Caden. All right, let's go in the courtroom real quick. Choke, no joke. I'm under fair use right here. Let's get into this, and then I'll talk about it more. All right. Instagram, go on my stories, hit the link. It'll bring you on the screen, or y'all can stay right there and listen. But if you need to see, you can go on my story. All right.
Proffer is a contract between two parties, and Vegas isn't one of the parties. So it's a contract that doesn't necessarily exist with that involvement. However, now we're talking about 2009. How do we get there?
So I think the problem is that when you look at it from the viewpoint of, I mean, did Compton and LAPD really hate Las Vegas Metro to the point where they just weren't going to disclose any of this information? That they wouldn't have said, hey, we met with this man. This man is saying that he knew some information about the murder of Tupac Shakur. And as a result, this is what's going on. That somehow they just kept all of that from Metro. I don't know. Because to me, the inaction of what happens next is the problem. 2008, there's no movement by the Clark County District Attorney's Office, which would indicate to me one or two things. Either they didn't know about the proffer, or an alternative, they knew about the proffer and chose not to do anything about it because of what you're seeing now from all these different people that Detective Mogg had interviewed, and that is, it's a proffer, we're going to stay away from it. Now, here's the thing. Say it's the second problem, and the second problem is they weren't notified. 2009 comes along, and what happens? Las Vegas Metro goes and interviews with Mr. Davis. They are no longer in the position where they can say, hey, we didn't know anything about this. They're meeting with Mr. Davis. They sit down with him. He gives his statement. He answers their questions, and they leave. What happens after that in terms of the Clark County District Attorney's Office? Nothing. If there was this discussion or this agreement that, hey, guys, that was your agreement. The proffer was between your parties, between the state of California and the federal government and Compton and LAPD. That would have worked for 2008. But what happens in 2009? So to me, when you hear what these attorneys or these investigators and detectives are talking about, is that there was an understanding that, hey, that covered it. Now, why would a detective go down and speak with this individual in 2009?
Navan, the #1 rated business travel platform, lets your team book work travel in one place. Flights, hotels, cars, while staying within budget and earning professional rewards. Right now, they could be giving you
to ask questions and clean up the file, to follow up on loose leads, to figure out where everyone was at or do whatever the case was in this particular case. That's why you would do it. Not to go down there and see if you can arrest the guy, but rather to say, hey, you know what? He's got the information. Let's finish up this file. To me, the 2009 Mogg is the one who really talks and really sort of indicates this. He says, he told Detective Ladd, we even sent a detective out here in 2009 who interviewed Davis with his attorney, and the LA detectives told me that, yeah, everybody was under the impression that that was still under this proffer, so I can't use any of it. What does that mean? Detective Mogg takes over the case in 2017. He knew about this particular person going down and meeting with Mr. Davis in 2009. And even he believed at that particular point that the proffer still covered whatever the interview was between Detective Long and my client. So that's the 2009 issue. Once again, we just believe that the statements made at the time of the meeting 2008 and 2009 were involuntary. It's not a matter of this immunity issue. I think it goes more fundamental to that. And that is, when you're given a statement like this, you're forced into a position because you're afraid of the consequences of saying no. And the consequences of what was happening here wasn't necessarily because Mr. Davis was afraid for himself, but rather the threats that were made against his family and his friends that was built up over time. Detective Kading agreed to that and said, yeah, we built up this case and we got him to a position. Now, when he's talking about building up to the sentencing guidelines, in the federal system, there are mandatory minimum sentences, and you have to accumulate over time. There's an objection you can make as a defense attorney. It's called sentencing enhancement. You basically wait until the amounts that are accumulating gets to a mandatory minimum 10 years, whatever the case is. That's what he's talking about. So they literally just sat and waited, and they just accumulated more and more information until they got Mr. Davis in a position where he was afraid, like I said, not only just for himself, but for his family. And that's our position with regards to the 2008 and 2009. I hope I did my motion justice. But with regards to the last issue, and that is the Compton, the book. What's interesting about the discovery that we received in this case is that we received an interview that Detective Mogg, I guess it's Mr. Mogg now, had done just recently. I don't want to say it was in the last like 4 weeks, 5 weeks, something like that, where the individual that's named in the book next to Keefe D or Dwayne Davis, Keefe D is what is on the cover of the book, is this person named Yusuf. The interesting thing about that is because Detective Mogg, for some reason, never made an effort to interview this person prior to submitting this case to the grand jury in 2023. Which you would think is sort of common practice. It's sort of commonsensical. It's what you would do because you got a name on a book, and then you also got another name as somebody who also wrote the book. And as a result, you've got two different people on there. Why not interview both people before reading the book into the record? Because it's not like he testified and said, this is what I do, and the book was part of it. He read excerpts of the book as if it was the gospel truth into the record on the grand jury. And so our position is that in this particular case is that, look, he finally goes and meets with the other writer, but the writer is not giving him the information that he wants. He's not saying, hey, I just received whatever Mr. Davis sent to me on an email. I just put it in the book. Whenever I did something wrong, he would correct me. It's not that conversation at all. What the conversation is about is like, hey, you know what? It's this idea that, hey, in the book, he sort of made it up. And I'm not talking about Mr. Davis. I'm talking about this other person named Yusuf. So to me,
Well, I mean, doesn't that disregard every single promotion of that book by your client?
Need help scaling your business? You need Upwork. With Upwork, you can find and hire freelance experts in over 120.
you know, the problem with the promotions are,
Yeah.
you don't raise your hand to tell the truth, the whole truth, and nothing but the truth when you give your promotion. You don't sit there at, in BET in the middle of this, 6-part documentary and you say, you know what, I'm going to tell the truth today. Now, you do expect to tell the truth. And what people do expect is that when you're questioned by law enforcement, that you are telling the truth when you're being asked questions about some investigation, right? There's an inference there that you are going to tell the truth there. But to a documentary and a promotion of a book, to me, the problem with the analysis is on some levels that we're putting way too much credence and value and weight on statements that are made for entertainment purposes only, not a confession to a priest, not a confession to a police officer, but rather to promote a book, to sell a product. And that's where we're at with it.
I think you used a really interesting word when you said the weight to give this, right? I mean, I don't know that there's necessarily a legal basis to keep this out, to keep the book out entirely, or admissibility. I think all of your arguments that you've argued about, Mr. B.I.G, and how this book was written and how it's composed, maybe you go to weight, what weight the jury should assign it as opposed to a legal admissibility issue.
Yes, Sean.
Okay.
And I think ultimately, just with regards to the motion, we do label out other parts of it, and just to get to the point at the end, once again, I think we have a huge problem here if we're going to say, look, his words in 2008, 2009, even based upon what these other detectives were saying that were present, people who understood what was going on during that time period, this was a proffer, all those things, I think on some level, all of a sudden now the state wants to say, well, we weren't party to that, but you were party in 2009. And on top of it too, it's law enforcement. I don't understand how that wouldn't be a thing with regard to each state honoring the efforts of other law enforcement with regard to their investigation, even if it's about the same thing. Maybe that's another issue that will go up on appeal, and that would be a different issue that would be decided with regards to new case law. I don't know. I just know at the end of the day, what we have here is we have an individual that gave an involuntary confession, who gave an involuntary statement because he was threatened. It's clear from the record, it's clear from the interviews with these previous detectives that was the issue, especially from Detective Katie, and as a result, we will be asking the court to suppress the 2008 and 2009 interviews and the book.
Okay. Turning to the state. It's the voluntariness argument. I think the voluntariness framework is what was really raised here. And I think the issue is sort of morphed into that of essentially when you're told this won't ever be used against you, that's possible, that's very coercive, and that's essentially renders it involuntary. But that really only essentially applied to the 2008. Did you want to be heard about all of the issues that Mr. Sanchez brought up?
Yeah, and just briefly, because obviously the book is admissible, the number of adopted mentioned, but I also think they're taking a lot of liberties with what the author said about the book. But the book is central to almost every other argument.
So you start with the book and work backwards.
Yes. If you notice, and I don't know if the court's read the entire book, we've given
I read these
segments of it before. And maybe we should supply the court an entire copy of the book, because you'll have a better understanding of all of the facts that are discussed within that book and how the trial will proceed and questions. We were actually going to file a motion in limine on what portions of the book the court is going to admit or not admit, although it becomes really interesting when a defendant is going to disclaim authorship of the book. We should be able to establish every fact he says in there, but there are some very prejudicial things that he says within there that are true, but maybe more prejudicial than appropriate. But that being said, this issue is right now authentication, I guess, is the really what they're arguing. And obviously, as the court notes, he adopted it by admission, whether he wrote it or not. So to me, the 2009 aspect, or sorry, the 2018 book, 19 book, really isn't in dispute here. The court's already sort of assessed the 2009 one, and I know that Mr. Samp said, well, what did the DAs know or not know back in 2009, and that should somehow be held against us. But the court, in the motion for immunity.
Do you spend all day in meetings, back to back to back to back to back? Find it hard to focus and actually get stuff done? Try Granola, the AI.
Reviewed, I didn't put Dan Long's affidavit, but also I did put Mr. Detective Logg's affidavit in here. In 2009, nobody from Las Vegas could understand the circumstances of that situation. And look, I don't know if you need me to address police officers aren't lawyers, but clearly police officer and lawyers, but might there have been a reason for Detective Mogg to have investigated this case without ever reviewing the 2009 case statement? The grand jury presentment being done without the 2009 statement, because at the time, we still didn't know what the circumstances were, and ultimately, we now do know what the circumstances are. And the only thing that matters is what Mr. Davis understood when he was in that room. And the only person who knows.
See, this is why they not going to bring Gray Caden into this case. Because they know that whole proffer deal is going to ruin this case, because y'all sat there and let this man tell y'all in 2008 that he was there when Tupac got killed. He came to Las Vegas in 2009 and told y'all he was in the car when Tupac got killed. And y'all did nothing. No, y'all did nothing. Y'all knew from 2008 that he told his story. Y'all did it. Y'all knew he came to y'all in 2009 and told his story. And you trying to say now, oh, well, we didn't understand the proffer agreement, so we didn't do nothing. Come on.
The situation in that room as to exactly the legal consequences of his conversation is the guy who negotiated the agreement with the federal government in 2008, Wayne Higgins. And if you read the transcript, you will see that Mr. Davis makes no inculpatory admission sufficient to charge him with a conspiracy in the crime. And when Detective Long begins to ask him questions about that, Mr. Davis asks to have a meeting. And I know Mr. Sam said, I don't know why they were still recording, but there's still a cop in the room while that conversation is going on. So it's not a privileged communication. And what the lawyer tells him is, hey, you gotta be a little fuzzy on some of these facts, because that guy out there wants to put a case on you. He can arrest you for murder. So you can't be telling him specifics. And Detective Dupree says, but you can't lie, because that'll vitiate your agreement with the federal government.
So clearly, somebody's in there telling KVD, yo, you got to be a little fuzzy about the fact. Like, you got to help us make up this story about this Tupac shooting. You can't say this. You can't say that. You need to just say what we tell you to say. This goes to show that KVD probably wasn't really there. Like, he's being coached into this. And then why only got a certain part of the session, the proffer session, recorded, and not the whole thing?
And so Davis makes the decision to talk to Dan Long. Now, why he made that decision or not isn't the issue. The issue that they're raising is voluntariness. He's not in custody. No promise has been made to him concerning that statement. And he clearly understands that the statements being made against him are going to subject him to a criminal prosecution for murder. And he's being told that by his lawyer. So 2009 is obviously admissible. Now you get to 2008. And look, your initial gut reaction from the content of the conversation in 2008 is, this shouldn't be admissible. But then you ask yourself legally, why isn't it admissible? So, voluntariness.
My knee-jerk reaction is because Detective
$5. That's how much I'm hoping you'll contribute to our campaign to take back Texas. $5 to defeat the billionaire mega donors and their puppet politicians.
Keefe goes out and says, this won't ever be used against you in any way, Keefe.
Correct. But that doesn't make the statement involuntary unless the promise is broken, and then there is still an analysis. And
Let's talk about broken promise,
yes,
because that's a bit of a,
right.
an interesting needle you're trying to thread here.
And I was going to get to that,
Okay.
right? And it's because Mr. Samt asked, why didn't we do anything in 2009? Well, we also didn't do anything in 2011 when Mr. Detective Keating, former Detective Keating, writes this book, right? We didn't use it against Mr. Davis in 2011 or when the
Yo, do you hear what they saying? Oh, we knew he did it in 2008, but we didn't do nothing. Oh, we knew he did it in 2009, but we didn't do nothing. Oh, we knew he did it in 2011, but we didn't do nothing. What? Oh, but then when he writes the book, y'all do something? Y'all had Gray Caden's confession in 2008. He came and talked to y'all, told y'all the story in 2009. 2011, and y'all still ain't do nothing? And you see it make it, yo, bro, this is crazy as what?
the tape is released later on that year to the documentary done by Mike Dorsey. That statement is that we didn't go, oh, we're going to run down here, we're going to arrest you, we're going to use the 2008 statement. That didn't happen either. But from a legal analysis, his argument is it's involuntary, Judge, not that a promise was broken in a contract. He's arguing that it's involuntary, that essentially saying that there was some sort of coercion to him. He got arrested and was subject to prosecution for a life sentence from the federal government for PCP and a kilo of cocaine. He is also subject to prosecution by the LA County District Attorney's Office for PCP and a kilo of cocaine.
So explain to me this, right? Keefe gets caught with a kilo of PCP and a kilo of cocaine. And they saying they got him on a murder. And this nigga walks out and never gets prosecuted for the drugs or the murder by the state or by the feds. Or because he went and helped them out with this Tupac story. They needed him to come and sit down and tell us this story about how Tupac got killed. And with him coming to sit down and give him this story about how Tupac got killed, that he allegedly supposed to have been there and did it, they let him walk for a kilo of PCP, a kilo of cocaine, which was a life sentence. They let him go because he told them a story about being there when Tupac got killed. And that makes sense to who? And you say he's not a patsy? What that they had him dead to right with a life sentence of PCP and cocaine. But they let him go because he told them he killed Tupac. And if you go look at my last upload, Keefe D said he helped them. They came to him for help. What did he help them with? To cover up who really killed Tupac. Allegedly.
And he's a third strike in California, so he's looking at a life sentence. And as he explains in his book, as you've read, he has to make a decision as to whether or not I want to talk to these guys or I want to fight the charges, and I knew they had me on the charges. So he explains in his book the voluntariness of his decision to have this conversation. And at the time, the police actually think he's responsible for the Christopher Wallace murder. They are not there to interview him about Tupac. It's during that first meeting that he tells them, hey, I know something about Tupac. And then there is the second meeting that there is a recording of from December of 2018. That may be covered by some agreement between the federal government, the LAPD, and Mr. Davis, to which he can, by contract law, hold them liable for it. The fact that Greg Kading, and that's why I say as a private citizen, later on released it to the public, is something that agreed to everybody who does this for a living, is something that just is it seems unfair to utilize it against them. Would you agree? And I think everybody in 2011 felt that way as well. But now you have to look at what the factual scenario is now.
Now you can generate video in Descript, create and use generative media directly in your edit with no fuss or clunky workflows, all in one place. Need B-roll? Done. Social clips? Easy.
Imagine, if you will, that a defendant goes into a police station and he gives a statement to the police that gets suppressed, that's highly detailed about his involvement in a murder. And the court suppresses it. And the defendant walks outside the door and says, everything I said to the police is absolutely true, but because the police screwed up, the statement is suppressed against me. Wouldn't we be able to charge him with everything he told the police was true, and then use the statement to establish the context of everything I told the police was true? 100% we would. And so in 2019, when the defendant decides himself to write a book where he describes a factual scenario all the way through conversations he had with his lawyer, all the way through the decision making that went on in his mind, all the way through the fact that he gave a truthful statement, and then all the way through the fact that he is so mad at Greg Kading for doing him dirty and by releasing it and demanding consequences for him. At that point, when he says I told them the truth, it's the same as the defendant who walked outside the door with an inadmissible statement. Whether or not it's admissible in 2011 is irrelevant to your analysis. He adopts it in 2019 in a book. He himself adopts it. Yeah, we put some waiver arguments in there and everything else, and their position on the book is it's fiction. So we should be entitled to establish what he said in that book is true. He did wind up meeting with his lawyer. The cops did go to his garage and explain to him, hey, we've got you on all these. Your brother Kevin, we got him on it. The other person that they mentioned that he got, everything he says in that book is 100% true. And then he does go down to his lawyer's office, and the court can't possibly find that a proffer situation is inherently involuntary. You'll be saying every proffer is inherently involuntary. What you're saying is that there was not a promise followed, but we're not relying upon Greg Kading's releasing of this information in any way, shape, or form. Had Mr. Davis never opened his mouth, had he never decided to take money and go on BET and talk about this situation, had he decided to never write the book, he would not probably have ever been prosecuted for the crime. But once he decides to write that book in 2019 and describe this situation, we are entitled to prove up what he's saying is true, including what he says about the facts, the liquid money.
See, this is where this prosecution is going to lose this case, right? They are going on this book saying that this book is facts. And here's the crazy thing. So you telling me this man can confess to Keefe, to Greg Kading. He can confess to the feds. He can confess to the state attorney. He can confess or BET Chronicles. He can confess on Vlad, Cam Capone, Art of Dialogue, all these places, and y'all cannot prosecute him until he write a book. So the book is what made it everything real, because he repeated in the book what was said in these documentaries and this, that, and the third. But let me show you where he gonna mess up at, where they gonna mess up their case at. Watch.
Mall incident, the MGM incident, the shooting incident, the aftermath, everything in there is now admissible because he chose to release it to the public. He chose to profit off of it. And therefore, whether or not Greg Kading violated the promise when he was a private citizen, it didn't change his agreement with the federal government. He becomes a...
See, and here's the other thing. They try to say, oh, when Greg Kading put out Murder Rap, he wasn't a cop no more. So he didn't violate anything. Nigga, that's still illegal. He still could have got sued. He just can't go and take police work that wasn't his solely. He wasn't a private investigator. He was working for the government. He just can't go take that and put it out and make money off of it. If that's the case, every cop in the world that ever worked on the case could go and take evidence home and go do a film on it.
Confidential informant in March of 2009. He does these trips. None of that is covered by any sort of proffer agreement. What he's doing is what the court knows, and I know Mr. Sanf knows in federal court, he's trying to provide substantial assistance to law enforcement because he can either get a no prosecution on his PCP or his cocaine, or he can get a 5K departure on whatever sentence he ultimately gets from any prosecution that occurs from it. He's not promised no prosecution for the PCP within that proffer that you see. Tim Seawright says, I only gave him a proffer letter for one occasion. We're willing to accept that multiple proffers are acceptable. But at the end of the day, nothing about what Greg Kading did retroactively makes this an involuntary statement.
How do you intend to use the 2001 proffer?
I intend to establish the factual scenarios that he provides in his book. And what he says is, my lawyer told me not to lie, so I didn't lie. And I told them the whole truth about Tupac. I had nothing to do with Biggie. And then I had planned to actually play the recording of him saying exactly what happened, which is consistent with 2009, and then consistent with there's been no motion to exclude the fact of a proffer, nor the fact that he becomes a confidential informant, he flies to New York, he meets with Zip, which corroborates the fact that he knows Zip. There's a conversation where he tries to set Zip up on a drug deal. All of that, none of that's covered by the proffer in any way. The sole issue for the court is somehow Detective Kading in 2011, when he's a private citizen and decides to make money off something that was a confidential document of the task force, is released. But that fact is irrelevant to the analysis of the court on admissibility, particularly since in 2019, the defendant describes the entire situation himself, and he does to a certain extent in 2017 on those recordings with BET.
Who's to say he's just not repeating what Greg Kading had in his report? You can't say that he's saying this factually when Greg Kading project came out afterwards. And this is why he say, yo, get the book from me. Don't get it from no fake ass cop or no dirty ass law enforcement, this, that, and the other. Get it from me, because Greg Kading already told the story, and he could be allegedly just repeating what Greg Kading put out there. You know what I'm saying? That's how I would look at it as a defense.
Create cinematic videos with C-Dance 2.0 on Artlist.
Okay. Mr. Stamps, anything further?
Yes, Your Honor, just a couple of things just in response. I think the court's first initial impression upon reading and seeing the evidence that's been presented to the court is right. It does shock the conscience on some level when you have openly a discussion with a detective who says, yeah, we promised them we were going to prosecute them. And all of a sudden here we are now arguing and saying either we're not privy to that, we're not party to that, or in the alternative that my client sort of waived some type of protection, which doesn't make any sense to me either. I think it shocks the conscience. It's one of those things where you look back and take a step back and go, what? Like, you promised a man this and then you turn around and do this later. The other part of it too is, once again, going back to this idea of voluntary confessions under Arizona v. Fulminante. It's extreme caution. There's a danger here that if we do something like this, give this information to the jury, that they will turn around and say, well, what else do we need? We just have his confession. He has lawyers sitting next to him. He, had every opportunity to talk to his lawyer, blah, 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 blah. But what we have instead is we don't have Miranda, we don't have any of the other things that would signal to Mr. Davis at the time that he's making the statements, that this is not one of those things where you just, frolicking through the tulips and at the end of the day, he's going to be okay. We are now in a position where we're saying, like, we want the confession to come in. The problem with the confession, once again, is it sort of puts us in a bad spot. Now, the question that the court might have in your mind is, what's the alternative? Well, the alternative is there's other evidence that the state has that they're going to present to say that, he's the guy that's there and he's the guy that's in the car and, whatever it is they want to use. But with regard to this particular request, this doesn't knock the case out. All it does is it says, hey, this is too prejudicial. That the probative value of the 2008 is far exceeded by the prejudicial effect in this case. And if we look at it from that viewpoint, we stay away from it. We don't get involved in it. We don't try to traipse in the middle. We don't clean up the mess that was made by other people in 2008. What we do instead, we say, look, we're going to move that off to the side. Let the jury consider all the other evidence in the case to make their decision at the end of the day as to whether or not the state's methods further beyond the bell. And so as a result, like I said, I think we have to have extreme caution with regards to the statements that were made in 2008. And I think it would be, the most prudent position would be to exclude the 2008, 2009 statement.
All right, starting backwards. I think really no question on Council Street Ledger. I find that as admissible under NRS 51.035 subsection 3. It's clear that Mr. Davis adopted the statements therein as his own through publication, promotion, and subsequent ratification. In his interview to Vlad TV, he promotes this book as his book. He encourages people to buy it to get the real truth and not from the law enforcement or industry people. He also repeatedly says it's something like the whole truth of the situation. So he's indicated to a reporter also on 10/21/23 that he wrote the book to let people know his truth. He's adopted its contents under NRS 51.035 subsection 3B. And then ultimately, when you look at the entirety of Mr. Jaw's interview, it supports that the factual content from the book was from Mr. Davis, and that Mr. Davis ultimately also got the manuscript and made no edits to the description of the murder that's relevant for today. Ultimately, the arguments regarding what Mr. Jaw's contributions to the book are, et cetera, goes to weight, not admissibility of the book. I really find there is no legal argument to exclude the book. Working backwards, then when I'm looking at what's in front of me, the motion is on voluntariness here, right? And so when I'm looking at voluntariness, I started this out saying, first I'm looking for, is Miranda required? And then I'm looking to those Pasama factors. And so ultimately, a criminal defendant is deprived of due process if the conviction is based upon an involuntary confession, and voluntariness is determined under the totality of the circumstances, including the age, intelligence, custodial status, and whether coercive police tactics overboard the will. When I look at Pasama, Dewey versus State, and then the Miranda decision itself. When we're looking at Miranda, it's only custodial interrogation. It doesn't require warnings where a defendant voluntarily provides information in a non-custodial setting. Statements offered against a party are admissible where they are the party's own statements or the party's manifested in adoption or belief in their truth. Neither required Miranda because neither ultimately were in a custody setting. He was free to leave at all times, and in fact, he did leave for decades after these were stated. So I don't think the Miranda framework is the appropriate one here. Additionally, it's important to note that he was represented by counsel throughout, and that is really what Miranda is. Miranda is designed to protect from police infringement on a person's ability to protect against coercion, and that's what the attorney's entire job is. When I look at the PSAMA factors that have been laid out, I don't think they apply here necessarily to establish involuntariness, really. If I apply that test, Mr. Davis passes with flying colors. I mean, this is a situation where he's an adult. He's not inexperienced in the criminal justice system. He has counsel present. He's expressly advised he is not under arrest.
Hi, I'm Greg. I'm an expert vetted top 1% AI consultant on Upwork. I use AI to help companies implement their technology, achieve scale, and get investors. Sign up for Upwork Business Plus and get access to the top 1%.
He's not inexperienced, he's not uneducated, he's not isolated, he's not subject to prolonged detention, deprivation, or coercive texts. I mean, he's invited to the situation. He comes to tell his story to avoid the federal government's issue. So I don't find it that it's involuntary either. However, I do have problems with that 2008 interview, but I don't think that they were necessarily addressed in the framework that I'm given here. So I'm not necessarily saying it's admissible. I'm saying it's not involuntary at this time. So the motion is denied as written. So you can prepare the order on that.
Thank you, Judge.
Your Honor, just as a matter of clarification of the court order, is this one of those things where we can redress this?
You can address it. I don't know what basis fits better, but it's not involuntariness framework.
That's fine, Your Honor, and I do understand the court's ruling with regards to that. I'm just trying to figure out in terms of timing and whether or not we can have the ability to redress it.
I don't really have a ton of guidance on what I'm saying. I'm just saying that the framework that you presented me with, it doesn't fit as an involuntary statement. You are free to redress it as you see fit under the legal guidance. Gang evidence.
Your Honor, this is the state's motion. Looking at the defense response and talking to Mr. Sams, I think we largely agree that it's admissible for the purposes of motive. So the real question, they took some issue with the purpose of identification, but we're not doing.
So, like I told y'all the other day, the book is admissible. They could put the book in the evidence. They could go through the book with the jury, this, that, other. The 2008 Greg Caden proffer session is in the garbage, right? Which is best for them because for me, I feel like Keefe D was coached a lot in that interview or that proffer session, whatever you want to call it. It was a lot of leading, so this happened, right? And then you did this, right? It's not like he just freely telling the story and they just jotting it down. They leading him into, so it was 4 of y'all here, and then you passed him the gun, right? It's all that to make it sound like a voluntary statement, but this is why excuse me. This is why his lawyer says involuntary, but it borderline is, but it's kind of hard to say it is when, Keefe D is collaborating, I'm going to say, with the goddamn Greg Caden and them on the story. You know what I'm saying? But you could definitely tell that, like he said, they told him the story, they showed him the board, and then they gave him 2 months to come pop up at the office after They done put it in his head what they wanted to talk about and what it was and the situation was. But like I said, man, I don't think that the prosecution has a slam dunk case. And if they going off the book and they saying the book is facts, I could show them the defense at least 3 things that they could pull from that book that's a lie. One, Keefe D said that he saw Suge and them at the MGM on that Friday. Suge and them didn't go to Vegas until Saturday. Second, if I was the defense, I would subpoena Big Meech. They said Big Meech from BMF was in the van with them when they went to go do the shooting, right? Justin, what up? Appreciate it. All right. Justin P in the building. Yeah, I would get Meech there. So since the prosecution wants to act like this book is gospel and Jesus, and Keefe D is Jesus or Moses telling the story, then I'm going to shoot holes in the book. You know what I'm saying? One, Tupac wasn't in goddamn Vegas on Friday or Suge. That's a lie. So I'm showing the jury all the lies in the book. Since you want to use the book and you want to act like the book is gospel, all right. Well, Big Meech was there when they went to go shoot up Tupac. Subpoena him, put him on the stand. I wasn't there. Oh, they go to credibility of the book. Suge and them wasn't in Vegas on Friday. They go to credibility of the book. Tupac shot at them first is in the book. They seen Tupac pull a gun and shit, and that was the first time Keefe D can identify with, let me see your hands. And Tupac shot at them first, pow, and that's when the fireworks started. Da-da-da-da-da-da. So let them see, pull up, bring up the people that did the crime scene and the investigation. Show that Tupac didn't have no GSR in his hands. In the car, in the ambulance at the hospital. When Chris Conley pulled him out the car, he didn't have no gun. When he got in the ambulance, he ain't have no gun. When he got to the hospital, he ain't have no gun. Y'all want to use the book as gospel? Okay, cool. Got you. And it's plenty of other lies in that book. You know what I'm saying? But if they think that the book is gospel, then Keefe D can't be lying because he wrote the book. Keefe D never even read that book, and you could tell. But we'll see what happens. But joke, no joke, y'all know what it is. Make sure y'all get that Tunnel documentary. It's out right now. All right. It's called The Hip Hop Nucleus on Tubi. Make sure y'all go check that out. And I'm here, man. I'll be back tomorrow. You know what it is. Hit that subscribe button.
No joke. Yeah. It's joke, no joke.
Make sure y'all hit that subscribe button. Choke, no joke. I'm here, man. I love y'all. Thanks for the support. Kiss the babies. Good night. Let's go.
Supreme Bigger Figure, Big Cap, The Warden, The Club King,
the DJ Johnny Walker Red,
MC Frank Jigger, the Celebrity's Choice,
Sean Brophy, sound engineer,
Choke No Joke, legendary videographer,
Sterling Cox, I was the head of security,
Alpha Grenier.
My name is V,
Omega,
Big G, Vim Rock from the legendary Naughty by Nature,
Styles P the Ghost, LOX, D Block,
Tech Smith and Wesson,
LB Fan, Mr. Cheeks,
the Cool, the DJ, the Red Alert,
Kid Capri.
The tunnel was a hip hop nucleus.
It was the epicenter.
It was the domain, the temple.
It was the Mecca.
Nothing was that melting pot of hip hop.
They kept the paradigm going.
It's almost like what Rucker did for street basketball. The tunnel was that of music industry.
My Sunday ritual going to the tunnel was
I'm telling you, your ass better be there.
You just pretty much did push-ups.
We had to drink a couple bottles of Hennessy, go get smoked.
Leave the jewelry and watches at home.
Before you even get to the tunnel, you gotta get on the block.
You started from 11th Avenue, and when you got to that door, the search procedures was no other.
First time I ever heard of take your shoes off, open your mouth was in the tunnel.
It was damn near everything but a full cavity search.
Security at the tunnel was no joke.
The beatdowns did happen.
Some of them, you had that chain out, that shit was leaving with one of them niggas.
We had a handful of cats. When we were taking you out, they were digging in your pockets.
The code check at the tunnel was crazy because you didn't know if you was gonna get your shit back.
Sometimes the bloops happen where you might not get your coat.
A lot of boys wanted to get their girls some fur coats, you know, so I mean, it was free.
The bar was always on till after the tunnel.
You might get fake alcohol. Bartenders might have got counterfeit.
The dance floor is always rocking. It looked like a video all the time.
The tunnel had a very unique situation at the bathroom. It was co-ed.
The bathroom was Sodom and Gomorrah.
I was like this, trying to look past the dudes like when they was going in the urinal.
The tunnel was a one-stop shop. They had food, they had alcohol, drugs.
I saw weed the tunnel. It was just oozing money. Backstage is like the club amongst the club.
That's where all the so-called stars who was scary to be in the crowd, that's where they hung out at.
The dopest things about the tunnel for me to remember is hearing my records get played up in there.
The top maybe of all time tunnel banger.
Or anything Bad Boy.
Every Biggie record, any shit by Hov.
Shook Woods was bananas in there.
Nori Capone, that bang bang.
Andy up.
Any one of Buster joints.
Wild Out would actually start a fight.
The best performance I ever seen, Jay-Z performed in front of the DJ booth. The DJ booth was bouncing like a ball.
Snoop and Dre. When Dre was there.
DMX, Get At Me, Dog.
The king of the tunnel was Jay-Z.
Busta Rhymes.
DMX is the king.
Queen of the tunnel.
Mary J. Blige.
Foxy and Lil Kim.
Eve. King of the tunnel record label-wise was Def Jam.
Bad Boy.
The best DJ at the tunnel was Flex.
Big Cap, all day. Flex used to break off the records, but he used to try to bully Cap, like, don't spin this, because when I get here, I want to spin it. No, nigga, fuck wrong with you?
What the tunnel did for artists, it solidified their street music.
That gave us a platform, set up Rough Riders, Rockefeller, Bad Boy, slew of other artists.
The closing of the tunnel, it was kind of sad because that was a big piece of hip hop.
So losing the tunnel was like a little kid losing Disney.
A famous mosque closing down.
I think when the tunnel closed, it was necessary. Niggas was coming to miss me.
When you hear people of the late 70s talked about Studio 54, the tunnel was the Studio 54 of hip hop.
Tunnel documentary out right now. Go get it.
Joke, no joke. Yeah. It's joke, no joke. Let's go. Joke, no joke. Chicken joke, no joke. Joke, no joke. Niggas joke, no joke.